There's a new law in California, AB 12, which limits the amount a landlord can charge for a security deposit to 1 month's rent, but small landlords are exempt. Hi, I'm John Tyner, owner of Tyner Property Management. We manage about 1,150 rental homes in the greater Sacramento area. I wanted to share some information about this new law, who it applies to, who's exempt, and what all is included in a security deposit under the law. And then what are the best practices surrounding this new law? AB 12 became effective on July 1st, 2024. This law caps security deposit at 1 month's rent, regardless of whether the unit is furnished or unfurnished. This law applies to landlords who own more than 2 rental properties and landlords who own more than 5 units, like an apartment. AB 12 is not retroactive. If you have an existing tenant with a double deposit, in other words, 2 times the rent for security deposit, and under the new rule you could only charge 1 time, that's grandfathered in. There's no requirement for you to refund a portion of the security deposit. So who's exempt from AB 12? Owners of more than 2 rental properties comprising of more than 4 units. So some examples are this: 2 duplexes, 1 fourplex, a single-family home and a duplex, or 2 single-family homes. Landlords who are exempt from AB 12 may charge 2 times the rent for unfurnished properties and 3 times the rent for furnished properties. One exclusion or exception for all landlords is that if your tenant is a U.S. military service member, the cap has always been 1 times the rent amount. When we talk about security deposits, it's important to understand that security deposit under the law is any prepaid rent other than the first month's rent. If you have a pet deposit, that pet deposit and security deposit cannot exceed the deposit cap. If you were to charge a last month's rent, which I don't recommend, that too would be counted in the security deposit cap. Some property managers are just reducing all their security deposit caps to 1 times the rent, just to be safe. I do not recommend that. The extra security deposit protects landlords, so wherever the law and the rental market allow for it, I believe you should charge the higher security deposit allowance. Tyner Property Management has surveyed all of our property owners, and nearly half of our owners are exempt from the lower cap amount, so we are still charging higher deposits for those owners who are exempt. Public perception is another thing to pay attention to. We're getting a lot of calls from tenants now who are trying to tell us it's illegal to charge more than 1 times the rent for the security deposit. This is understandable because many news articles only cover the general rule and they don't cover the exemption exception. So it's important to be prepared to educate people when they call. Best practice is to know where you fall under the law. Are you exempt or subject to AB 12? And then set your asking deposit amount accordingly. Be prepared to educate the public if your rental deposit is more than 1 times the rent. Know what's common in your rental market and be competitive. We have a lot more information to share, so be sure to like and subscribe, and we'll talk again soon.
John Tyner and/or Tyner Property Management do not provide tax or legal advice. John is neither an attorney nor a tax professional. This material is prepared for informational purposes only and is not intended to provide and should not be relied on for tax or legal advice. You should consult an attorney and/or tax professional for your specific needs and situation. If you would like to talk to us about professional property management for your rental home, you can reach us at 916-974-6003 or email us at info@tyner.com. And you can also visit our website at tyner.com.